Blog Talk Radio.
Welcome. This is Andy Marino with the LinkedIn group for food outbreak and recalls. Today's discussion will focus on food outbreak litigation with attorney Bill Marler. Just to give you a brief introduction, Bill's an accomplished personal injury lawyer and national expert in food illness litigation. He's been a major force in food safety policy in the United States and abroad. He and his partners at Marler Clark have represented thousands of individuals in claims against food companies whose contaminated products have caused serious injury and death. His advocacy for better food regulation has led to invitations to address local, national, and international gatherings on food safety, including recent testimony to the U.S. Congress Committee on Energy and Commerce. Marler Clark is considered the nation's foremost law firm, representing victims of foodborne illness and other serious personal injuries. Bill?
I am here.
I'll introduce you in just a second here. I believe you're online. Is that correct?
I am.
Awesome. With that introduction, would you like to give a little more introduction to you and your firm?
You know, Andy, I think that's more than enough. Thank you very much.
That was directly from your law firm's website. Thank you for coming today on our show. What I'd like to do is to discuss 4 principal issues for our group. And those issues, I'd like to begin with the first one, which is when is a legal action required as a victim of food outbreak or recall?
It's a good question, and maybe I'm being a lawyer focusing on required. I think the way I look at food safety litigation and when it may or may not be required, those are, in some respects, at least for the injured party, is a very personal decision, and especially if that injured party is a consumer. Certainly, the more severely injured a consumer is, the more their medical bills are, the larger their wage loss, the greater their loss. The more likely it is that they're going to come forward and hire an attorney and move forward with a claim. There are other kinds of consumers as well, and we've seen that in a lot of these major outbreaks where the consumer might be the chain of distribution, where there are recall costs and business losses that can become very, very complex over time. But perhaps I'll sort of focus on the consumer as a victim, as the individual that I would represent. And again, it's a very personal decision. But many of these people may have wage loss or medical expenses that can run into the hundreds of thousands, if not millions of dollars. I've had clients who've been hospitalized for 2 years, with medical bills exceeding $5 million. People who will never be able to work again or require kidney transplants or lifetime care. Those are really, really, really expensive, propositions for these people, and many of them, understandably seek compensation.
Outstanding. When you mention millions of dollars, I'm thinking dialysis. I'm thinking even death for some of these consumers.
Oh, most certainly. Many of your listeners, and I'm sure you do, remember the front page story of New York Times of my client Stephanie Smith, 20-year-old dance instructor, eats a hamburger, develops hemolytic uremic syndrome caused by E. coli, and is now bound to a wheelchair with all the attendant consequences of paralysis. And in addition, her kidneys are damaged, and she suffered a fairly significant, brain injury. So, certainly not the life that she intended. And, certainly, I think for, anybody, thinking that kind of thing shouldn't happen when somebody eats a hamburger.
Well, that's an interesting food item that you've picked out of the food menu. What about spinach, lettuce, tomatoes, and then more recently, cantaloupes?
Yeah, it's our shopping basket starting to look a little bit more ominous at us than it used to. Certainly when I first started doing these cases in the Jack in the Box outbreak in 1993, I think we really were thinking of things in a relatively more limited ways of what food items could get contaminated and sicken us. We thought of, eggs with Salmonella enteritidis, chicken with Campylobacter. You never really thought about, lettuce with E. coli 0157, and certainly, cantaloupe with listeria. This listeria outbreak that, we've been seeing hit us in the last month that I think unfortunately will go on for another 30 days or so. Nearly 100 people sick, nearly 20 people dead. It's just been, stunning in scope and just really tragic. This week I spoke to a, family, who lost their 80-year-old father and a woman who lost her, husband of, 60 years. And it's from eating a cantaloupe. A 56-year-old gentleman from Kansas who had leukemia, was in remission, doing really well, and preparing to, undergo a bone marrow transplant, which was expected to be very successful, and he dies. And I just can't imagine the roller coaster that family had been on, over the last year, and to end it, with a cantaloupe slice is just, sometimes it's just unbelievable, I think is the best word to describe it.
Well, Bill, I think you'll agree that we've established that these products have damaged individuals. You have represented them. The question that follows from that, which are the potentially liable parties?
Well, I think a good example might be, this listeria outbreak, and because I think it, in many respects, sort of explains the, how a food product liability case works or doesn't work, and the parties that can be involved. In this particular case, food product litigation sort of focuses on the manufacturer. Who's the manufacturer? And the term manufacturer, the word manufacturer, is very broad in this context, and it's someone who grows, someone who does something to that product, and that would include growing it, washing it, shipping it, and certainly can be in some instances even the retail outlet. Retailers tend to have some level of a higher standard or a burden that we have to show that they did something more than that they had some knowledge that the product could be contaminated. So in this particular outbreak, the target defendants would be the grower, Jensen Farms, which also processed it, and the shipper, Frontera, which not only shipped the product, but also its name was on the label, which also creates a sort of another level of liability. If you put your name out there on it, you buy the problem. What's going to be interesting is, given the size of this outbreak and the severity of the illnesses, whether or not Jensen Farms and Frontera may have sufficient assets and insurance to cover the losses, and they may not. And if that's the case, the retail outlets who sold those cantaloupes to consumers may well be left holding, the financial bag, so to speak, and be held liable simply because they sold a product that was contaminated from a manufacturer who has no assets.
Well, that really cuts a wide swath along the food chain and there's a coined phrase, from the farm to the fork. And in your litigative process, so you're saying that potentially liable parties are all of them.
It does, yes. In a broad way, that's true. It varies a little bit from state to state. There's some states that give a little bit more immunity to retailers than others. But the one sort of common denominator amongst all the states is, even in situations where a retailer is relatively immune, if a manufacturer is, for example, overseas and the victim cannot get service on them, or the manufacturer or the shipper has insufficient assets to cover the damages, the retail outlet will be held responsible, because as between the consumer and the retailer, shipper, grower, the law presumes that the victim has a right to be compensated, and that the retailer who sold it, the shipper who shipped it, the manufacturer who made it, bear that responsibility.
Very interesting, particularly with your emphasis on in the cases where the product comes from overseas, and what you mean is imported into the United States from another country.
Correct.
You'll find, I think this is a general statement, during the summer months, a lot of the produce is local, but some of the produce during the winter months is actually imported from quite a distance.
Absolutely. And, what it really does tell you is that, growers, in the United States who then may import products, during winter months, those shippers, those importers, and even those retail outlets, it really behooves them to pay a lot of attention to, the quality, of the growers, whether they're, inside the United States or outside. But from a, if something goes wrong perspective, having a solvent, entity, in the United States, or the ability to attach, by contract, the assets of a outside the United States party, becomes, critical, depending upon the size of the outbreak.
Outstanding. What I'd like to do now, Bill, is focus a little bit, you mentioned it earlier, on the basis of evidence which best supports bringing forth litigation to represent your client. Sure.
This is where most of the focus of what I do is in evaluating a claim to determine whether or not, on a more likely than not basis. So that's the standard, that most times I can prove that the product that sickened my client was in fact that product. And there are a lot of tools to do that. And a few years ago I wrote a sort of a how-to manual. It's called Separating the Wheat from the Chaff. And I have it up on my blog at marlerblog.com. And it's a really, I think it's a pretty interesting sort of viewpoint of how to prove a foodborne illness case, but also how to disprove a foodborne illness case. In a sense, you could reverse engineer it. But primarily what we look at is, did the product cause the illness? And, if you focus at the listeria outbreak linked to cantaloupe, is there a positive listeria test result from the blood of the victim or the spinal cord fluid of the victim? And are they a match to the outbreak, and in this instance appears to be strains? That's really good evidence that there's a common denominator between a lot of people, and the common thing that they consumed was cantaloupe. The evidence gets better if you can find leftover cantaloupe, which they found in this instance, and then it gets even better if you find evidence of listeria in the packing equipment, which they did. So, the proof of causation that product from that farm and this shipper caused damage is pretty overwhelming in this listeria case. It gets more complex, and likely cases that I would never take would be cases where there was no positive culture, and you're trying to put together a case saying, I've got a receipt and I had, an illness. That becomes the type of case that it certainly is possible that they were sick, but if, it is my burden and my client's burden of proof to prove that in fact it did. And, as you start to unwind some of that scientific evidence, it becomes much more difficult to prove a case. So most of the time, probably about 80 to 90% of the cases that come to our office are cases that we review, and we send people, along the way, saying that it's not a case we could take because, in our view, it's not a case we can prove.
Outstanding. So 80 to 90% of the cases that are proposed to you by allegedly damaged clients may not have this best evidence to support your litigation. Is that correct?
Yes.
As we look at the types of tests the government runs, they run the culture, which is the inoculating the glass plate in a gel medium, or there's also the cold steel gel electrophoresis, which is reported food. Do you bring those experts in from the government as well?
Well, not from the government. The government tends to, certainly we use the data that's generated there. But what we do is we try to bring in, all the parts of the puzzle. The PFGE, and certainly some of the, more recent uses of MILVA, and in addition, traceback records. Having a whole bunch of people throughout the United States that have the same PFGE pattern of E. coli or Listeria doesn't really tell you what the product is. You really have to have, good product ID, which is very problematic in many instances, especially in Listeria cases, and I think in many respects why you don't hear a lot about Listeria as an outbreak in food as frequently as you hear it in Salmonella or E. coli, because the incubation period for Listeria is so broad, 3 to 70 days, and to try to ask a 80-year-old who's been hospitalized for a month and a half what they consumed 70 days ago certainly is creates an issue, and so many times it becomes a situation where you're not able to prove that case because you're trying to put together all the pieces of the puzzle, and when you have missing pieces, it makes your case sometimes virtually impossible to prove.
Well, that's a very interesting point that you bring up about traceback records. With the passage of the new Food Safety Modernization Act, one of the requirements is that these food producers perform mock recalls and that their records be in order and that they have certifications, whether they're foreign or domestic. Do you think that's going to help food producers and maybe yourself identify these cases more rapidly and accurately?
Well, I think in some respects, I've always been a really big proponent of as much surveillance as possible, and rapid surveillance, and rapid, getting products off the market. I certainly got some pushback by my friends in the industry to say, well, they're just trying to get more cases, and to be honest with you, that's sort of completely the opposite. The quicker outbreaks are figured out, the quicker along the epidemiological curve and early in the epidemiological curve that you can get at a problem and say there's an outbreak and start the recall process, the less likely it is you're going to have very many people, and certainly the less likely that I'm going to have very many clients. Most outbreaks, if you go back over 20 years of epidemiological curves at the CDC, most outbreaks are figured out long after the outbreak is over, or nearly so. It's on the downward slide of the curve. People are sick, and it's been the consumer who's been the canary in the coal mine to alert that there's an outbreak. And so government does, and labs do, and public health does a pretty good job of tracking outbreaks, but we really could do a far better job of coordinating that activity between state and local government and the CDC, FDA, and FSIS to jump on outbreaks sooner, stop them on the upward slide of the curve, and get these outbreaks figured out a lot faster.
You bring up an interesting point, and it leads toward our last question, and that is the social responsibility or the social impacts. So I'll address this question. What are the social impacts of these legal actions for plaintiffs, the food producers, and the food system?
That's an excellent question, and I'd like to start sort of my answer by something that might seem a little counterintuitive for a lawyer who represents victims. But consumers bear responsibility for protecting themselves as well. And when you talked earlier about the sort of the farm to fork example, consumers need to become more educated about the food they consume, and being more aggressively informed about the safety of the food that they consume, and really sort of demand that food be safe. And they also take responsibility for many of the things that we've sort of let go by the wayside. Washing our fruits and vegetables thoroughly, making sure that things are chilled that are supposed to be chilled, or heated appropriately, that when they need to be heated, and to really understand that bacteria and viruses carry enormous risks and enormous financial costs, and certainly in litigation, there have been instances where the defendant has claimed that the plaintiff, the consumer, bears some level of contributory fault for the injury they sustained. And in the right instance, that certainly may be legitimate. For example, perhaps if you and I decided to eat, raw hamburger, and we both got E. coli 0157, a jury probably wouldn't be very sympathetic to that. However, if a 17-year-old kid was cooking a frozen hamburger patty and developed hemolytic uremic syndrome and became paralyzed, a jury would be much more empathetic to their knowledge of foodborne contaminants. So it is one thing to keep in mind. The legal system does allow for responsibility to shift a bit between the various parties, from the plaintiff, to the retailer, to the shipper, to the grower. The social aspects, social impacts of these outbreaks and litigation on plaintiffs, food producers, and the food system, can be pretty profound. As a lawyer who's taken some $600 million from food producers on behalf of my clients in the last 15 years, that's not an inexpensive proposition, and it does have costs. It has costs, to insurance. It has costs to business reputation. It has costs to sales. Some companies have gone bankrupt because of that. So, the costs can be, very profound. On the other hand, these outbreaks, we look at all the things that have happened because of them. increased cook temperatures, increased use of pasteurization, leafy green marketing agreement, following the spinach outbreak. And I'm convinced that there'll be some positive results from this horror that we're seeing in the cantaloupe listeria outbreak. But I think having a better understanding of the legal system and how it really operates and the impacts on victims, and that these are real people with real, there's 20 of our friends and neighbors who've been killed by cantaloupe, and they were leading lives, and they're they had important things to do, to be with their families. And I think we really have an obligation to them to try to look at what we can do through the legal system and otherwise to make our food supply safer.
Outstanding. What really struck me was your statement of $600 million in judgments against food producers protecting your clients. In the few minutes that remain, I would like to allow you to advertise your services in appreciation for your participation today. If you'd like to let our listeners know about your services and the types of cases that you entertain.
Well, my law partner, Bruce Clark, who I fought against for 5 years. He was chief counsel for Jack in the Box, formed Marler Clark in 1998 after I successfully prosecuted the Odwalla E. coli outbreak on the West Coast. And since then, Bruce and I and now 6 other lawyers, a total of 8 of us, do nothing but represent victims of foodborne illness across the United States. I also spend about half my time speaking around the world on food safety issues, and I feel that's sort of an obligation that I have to try to prevent many of these illnesses from happening again. So we work very hard at what we do, and the sort of driving force at this point in our career is to try to limit foodborne illness outbreaks so we can retire gracefully.
Well, Bill, thank you for your time. Appreciate it. You're a busy man. And I'd like to close with a sincere appreciation from our group for your legal expertise and your outstanding efforts to help both plaintiffs and actually help refine the food production process and improve our food system.
Thank you very much, Andy.
Thank you very much. And we'll now close this session. A big thank you to all our listeners.